This is Bloomberg Law with June Grasso from Bloomberg Radio.
I have a open spot on the Federal Reserve Board. I'm very happy about that.
President Donald Trump suddenly has a chance to fill an opening at the Federal Reserve earlier than expected after Fed Governor Adriana Kugler announced her resignation on Friday. Kugler's exit unfolds amid unprecedented political pressure from the White House on the central bank over monetary policy, with Trump often launching personal insults at Jerome Powell, the current chair. Joining me is Kathryn Judge, a professor at Columbia Law School. Kate, what's your reaction to Kugler's departure?
I was surprised. She is the next governor to leave naturally. Her term expires early in 2026. So it's clearly a spot that President Trump is going to be able to have available in the relatively near future. But this short window of time changes dynamics in a meaningful way. Among other things, her spot was seen as a likely position for the person that President Trump would like to bring in to be the next chair. So this really potentially accelerates that process and could lead to even more intense pressure on Powell to step down from his position as chair.
When President Trump was leaving the White House on Friday, he said that he was very happy to have an open spot, and he told reporters that she was stepping down because she disagreed with, quote, too late on the interest rates. That's his derogatory term for Powell. But does that align with her publicly stated views?
We have not seen anything to that effect in what she has stated publicly. We have seen disagreement between Kugler and Michael Barr on the one hand and other members of the board on the other hand on matters of regulation. And it does look as though the current board, under the effective leadership of Vice Chair for Supervision, Michelle Bowman, is going to engage in a deregulatory agenda. So on that front, it does look like there was a difference of opinion, but that's not necessarily a reason for her to accelerate her departure. If anything, that's a reason for her to stick around and to let her voice and vote be heard.
Trump says he's going to appoint the next Fed governor. Will you explain why he basically has to appoint the next Fed governor to fill her spot?
So he has to choose the chair among the governors. Powell's term as chair expires in May of next year. His term as governor doesn't expire until 2028. It is possible that Powell will step down as governor at the same time he steps down as chair, but that is by no means guaranteed. And because there are no other additional slots open, Chris Waller, who is a Republican, who Trump previously put on the Board of Governors, is a possibility for Fed chair. And if he wants to promote Waller, then he wouldn't need to use this slot for purposes of introducing somebody who would then take over as chair. But if he does want Kevin Hasset or Kevin Walsh or any of the other names that have been bandied about, this slot might be his critical opportunity.
Are there any indications as to whom he's favoring for the role?
There have been rumors that Hasset has been taking over as lead. Kevin Walsh's name has been around for a long time. We've certainly seen both of them actively campaigning for the job in their public statements and have been very supportive of the lower interest rate policies that Trump would otherwise like to see in place. But we have heard nothing official from the White House with respect to who's likely to be the next nominee.
The Open Market Committee voted 9-2 to leave rates unchanged. So one more vote won't necessarily make a difference.
It's hard to know. I mean, and this is really hard. So first of all, the Fed is already facing an environment in which they might be changing course independent of a new chair coming in. The most recent jobs numbers look weaker than they expected, and there have been some revisions. So a variety of reasons to think that there might have already been a modest change in course underway. But you're right. I mean, one of the key things to keep in mind is the Federal Open Market Committee is a 12-member committee, and the chair or kind of the expected chair is only one of those votes. And so one of the things that Trump has to kind of keep in mind and that we all have to keep in mind as we're watching is how effective is the new chair going to be garnering support for a meaningfully different trajectory for policy. And that's going to be one of the open questions as somebody new comes in, both what is the interest rate trajectory they want to see and what are the tools they're going to use to try to convince fellow members of the Federal Open Market Committee that actually a different policy course is for the best.
In the past, have Fed governors not been able to convince the Open Market Committee to do what they want?
What we haven't seen in the past is quite as clear of a mismatch between what the president wants to see happen and what the current interest rate policy is. So we've certainly seen nominees come in because they are meant to kind of change the trajectory. Paul Volcker famously was appointed because there was suddenly an appreciation that inflation and managing inflation had to be the priority. That being said, that was an insight that the board also shared and that President shared. So he did have some struggle at times with aspects of his policy getting the level of support he wanted. On the other hand, he was actually pushing against the president, pushing against short-term political will, and pushing for kind of a longer-term vision that aligned with the core mission of the Federal Reserve, which is fighting inflation and promoting maximum employment. So in that instance, it was a very different set of dynamics. And so this is a different type of transition because we have a president who's just been so outspoken for such a long time about wanting monetary policy to look dramatically different than it has.
Have you ever seen this kind of pressure from the White House on the Fed chair?
No, no one has. We've certainly seen pressure from the White House on the Fed chair in the past and on the Federal Reserve in the past. The classic concern is that the president always wants monetary policy to be somewhat more accommodative than the Fed oftentimes wants it to be. There are certain times that those interests are aligned. During a depression, during difficult times, accommodative monetary policy is the right policy given the Fed's dual mandate. But in moments like now, where the Fed's looking long-term and trying to think about what does it need to do to make sure that it successfully fights off the recent bout of inflation, there's a possibility for conflict. And so LBJ famously kind of pushed around William McChesney Martin. So we've certainly seen presidents in the past that have pushed around Fed chairs and pushed around the Fed. And that's because they oftentimes do want monetary policy to be somewhat more accommodative than is prudent, given the medium to longer term interest in trying to maintain stable prices. And that's when those conflicts have come into place. But what we haven't seen is this type of continual pressure where the Fed chair is really targeted in an ongoing and repeated way. And where the president isn't just suggesting that rates should be a little lower or that monetary conditions should be somewhat more accommodative, but is really seeking what seems to be a very different approach to monetary policy than the current Federal Reserve is pursuing, at a time where there is still some reason, at least, to worry about inflation.
The nominee, whoever Trump chooses, will have to be confirmed by the Senate. But if that person is then chosen as the chair, that does or doesn't need Senate confirmation.
That also is a Senate confirmation process. And there's also this additional oddity. This person is going to face kind of the ringer. There's a Senate confirmation to fulfill the remainder of Kugler's term. But the way the Federal Reserve works, oftentimes for agencies, once you are confirmed, you have a period in office that dates from when you are confirmed. So you might have 5 years from the time you actually take office, for example. The way the Federal Reserve works is there are these 14-year terms on a staggered basis. And they are 14-year terms in part to limit the ability of any one president to appoint too many different governors, but partly because of that distinct staggered structure. When somebody is nominated to fulfill a seat for somebody who's leaving before their end of the term, as Kugler is, they only are confirmed to the end of that term. So in theory, if this person manages to go through hearings and confirmation in time to fill the seat before it would naturally become vacant, there might have to be a nominal second process to have the person actually confirmed again when the term expires.
Trump on Friday called for the Board of Governors to usurp the power of the Fed chair. He said, in all caps, the board should assume control and do what everyone knows has to be done.
I mean, there's a lot of things to say there. So first of all, as we were discussing earlier, each member of the FOMC is not just the board. The FOMC, the Federal Open Market Committee, which determines monetary policy, is a 12-member committee. So all 7 members of the board of governors have votes on that committee, but so do 5 presidents. So the policymakers involved are not just governors, and the governors are exercising their independent judgments. We saw 2 governors actually dissent, and they did suggest that more accommodative monetary policy was appropriate. But we saw the rest of the governors go along and actually agree with Powell that the preferred approach was the right approach to take.
The Supreme Court, in a May decision, suggested that Trump couldn't remove Powell because of policy disagreements. Is there any feeling for whether the administration is still trying to get him removed?
Yeah, I mean, there's 2 different issues. So one, we did see this effort with the renovations, which really looked pretextual, right? What we know is Trump wants lower interest rates. He blames Powell for the interest rates being what they are. And so he was looking at the cost overruns and trying to use that as potentially a basis for removing Powell for cause. That has seemed to have passed, at least modestly passed, but it does suggest that Trump might still be on the lookout for other pretextual grounds for removal. The other issue that remains an issue, particularly, and actually becomes more of a live issue since Kugler is stepping down, is might he try to appoint somebody else as chair and not remove Powell, but merely demote Powell? And here the law is a little tricky, and the Supreme Court decision, which wasn't even really a decision, it was part of their shadow docket, didn't resolve the question of whether Powell can be demoted. The statutory language is very clear. Governors of the Federal Reserve can be removed from their role as governors only for cause. So there's very clear statutory protection there. By contrast, the chair and the various vice chairs have 4-year terms as opposed to 14-year terms, and there's no explicit for-cause removal protection. There's arguments that he can still be demoted only for cause and not for policy differences, but there is a real risk that that legal question will be tested in a more pressing way now that the window of time between when he can get a new nominee onto the board and when Powell's term as chair comes to a natural end, now that window has become longer.
This falls into the more questions than answers category. Thanks so much, Kathryn. That's Professor Katherine Judge of Columbia Law School.
The U.S. Treasury has taken in $150 billion from tariffs, and we'll be adding about $200 billion next month for totals that nobody's ever seen before, frankly.
But the challengers to President Trump's tariffs say they rest on a, quote, breathtaking claim to power that no president has asserted in 200 years. And a federal appeals court appeared skeptical about Trump's authority to issue the sweeping global tariffs under an emergency law that has never been used for that purpose and doesn't even mention tariffs. In May, the U.S. Court of International Trade ruled that the vast majority of President Trump's levies were issued illegally and ordered them blocked. The Federal Circuit Court of Appeals gave the Trump administration a temporary reprieve. But during the high-stakes oral arguments last week before the circuit's entire slate of 11 active judges, it appeared that several were skeptical of the government's arguments. A decision finding against the tariffs will almost certainly be appealed to the Supreme Court. My guest is Jimmy Gurule, a professor at Notre Dame Law School and the former Undersecretary for Enforcement at the Department of the Treasury. Jimmy, will you start by explaining what authority President Trump is using to impose these tariffs?
Yeah, President Trump is using a law called the International Emergency Economic Powers Act, and it goes by the acronym IEPA. And IEPA does authorize the president to impose economic sanctions on individuals, entities, even countries in response to an unusual and extraordinary emergency. So that's the precondition for the exercise of these economic sanctions. The president has to declare that there's an unusual and extraordinary emergency that has its source in whole or in substantial part outside the United States, and further, that threatens national security, foreign policy, or the economy of the United States. So that's the statute that the president is relying upon. There's a couple of very serious problems with using IEPA. First and foremost, IEPA never mentions tariffs. The word tariff does not occur even one time in the text of the statute. And second, IEPA was enacted by Congress in 1977, and no president in the history of IEPA has ever cited IEPA as authority to authorize the imposition of tariffs. So this is the only president in the entire history of IEPA that's ever cited IEPA's authority for imposing tariffs on foreign countries.
The challenges here were a group of Democratic-led states and small businesses. What was their basic argument?
Their basic argument was first that IEPA just doesn't apply, that it does not provide authority for the president to impose economic sanctions. And again, for the reasons that I just articulated, tariffs not mentioned in the statute, no president has ever used IEPA to justify the imposition of tariffs. So that's argument number one. Argument number two is that even if IEPA did apply, that there's some serious questions about whether or not the president is properly using or satisfied the requirements of IEPA. For example, what is the unusual and extraordinary emergency that justifies economic sanctions in the form of tariffs? And here the president has articulated many different so-called emergencies. On the one hand, it's a trade deficit. That's the unusual and extraordinary emergency. On the other hand, it's the fentanyl crisis, the importation of fentanyl from Mexico, Canada, and China. And third, he's even cited immigration. The immigration is the emergency. But first, there's a question about, well, is the trade deficit really an unusual and extraordinary emergency? We've had trade deficits with countries around the world for decades. That's nothing new. Trade deficit with China, trade deficit with Mexico, Canada, with the EU. That's nothing new. So what is so unusual and extraordinary about trade deficits today that, again, triggers the application of IEPA? And then there's another problem with the actual application of the statute. And when we look at the fentanyl crisis, for example, approximately 88% of fentanyl that's consumed in the United States comes across the Mexican border, the border with the U.S. and Mexico. Only 8% comes across the Canadian border. So if IEPA is being used, or the emergency is fentanyl involving the importation from Canada, Canada is only responsible for a very small percentage of fentanyl coming across the U.S.-Canada border. So there doesn't appear to be a nexus or a close nexus between the so-called crisis and the targets of the tariffs and the sanctions that are being imposed on various countries.
So what was the government's response to that?
One response is that, well, this involves foreign affairs. And in the area of foreign affairs, the Supreme Court has recognized that the president has plenary powers. The government needs to speak with one voice in dealing with foreign affairs, and that one voice should be the president, the executive branch. So it's, again, the president has plenary, virtually unlimited powers in dealing with other countries. On the other hand, that argument runs into a serious problem, and that serious problem is the U.S. Constitution itself, because Article 1, Section 8, Clause 1 states that Congress shall have the power to lay and collect taxes, duties, imposts, and excises. And tariffs are really a form of a tax. It's a form of a tax. And therefore, the power to lay and collect taxes falls within the power of Congress, not the president. And I think there's one other very important argument, and I don't think it came up in this recent argument before the U.S. Court of Appeals for the Federal Circuit. And it's a very basic fundamental principle of our democracy. And our founding fathers were very concerned about too much power residing in the hands of any one person or any one branch of government. And that's why we have a democracy based upon separation of powers. And here, if you follow the government's argument and reasoning, then the president has this unlimited power. One person can decide to impose tariffs on any country or every country in the world, can decide what the percentage of the tariff should be. Should it be 10%? Should it be 25%, 125%? Against what countries and for what reason? And so it seems to me that the president's position really flies in the face of this very fundamental bedrock principle of separation of powers on which our democracy is based.
So the panel of judges seemed to sharply question the government's position. One judge said tariffs seem to have no friends in the text of the emergency law. Do you think that a majority of the judges might rule against the tariffs?
I think based upon the questions and the tenor and some of the questions that were asked during the oral argument, I think the federal appellate court is very skeptical of the government's position that IEPA provides authority for the president to impose tariffs. So I'm cautiously optimistic that the appellate court will likely, reject the government's argument and then find that IEPA has been misapplied here. So then the critical next question, the critical next step is going to be before the Supreme Court. Because if the government loses, there's no question that they'll appeal the matter to the United States Supreme Court. And there, the outcome is really up in the air.
Because it's an en banc panel, the decision here can be appealed directly to the Supreme Court.
Yeah, and there what we've seen is that, historically, just, the first 6 months of the Trump administration, the U.S. Supreme Court has been very deferential to the executive branch with respect to claims of executive authority by the Trump administration. The Supreme Court determined first and foremost that the president is immune from criminal prosecution, except in very, very rare, limited exceptions. And the president can on his own, dismantle federal agencies without consulting with or obtaining the approval of Congress, can withhold funds that have been appropriated by Congress, and fire inspector generals, and fire other key government personnel without any consultation or approval from Congress. And so the president might gain a more favorable audience before the Supreme Court than he received before the U.S. Court of Appeals for the Federal Circuit.
Is Supreme Court precedent on the challengers' side? They cited two of the Biden administration's biggest losses before the Supreme Court in fights over restrictions on pandemic-era evictions and canceling federal student loan debt to support their position that Trump now can't try to read more power into the economic emergency law than it offers on its face.
Well, here's the difference. I think the difference here is that the Supreme Court, again, could focus on the fact that these tariffs involve foreign affairs, and the president is the sole organ for the country on issues involving international affairs. The cases that you cited involve domestic statutes, domestic law, not international foreign affairs. And so here, the court might seize on that, recognize, the president has all his plenary powers in the field of foreign affairs, and again, be more sympathetic, to the argument. At the same time, if the court were to rule against the president, just think of the repercussions of that ruling with respect to the tariffs that the president has set, the tariffs that have gone into effect, the tariffs that are going to be going into effect in a few weeks. It would have just literally global ramifications if the Supreme Court held that the president did not have the authority to impose these tariffs on countries across the globe.
Could the U.S. then be forced to refund duties that have already been collected?
Would the ruling be retroactive? Would the ruling just be, prospective? And so the scope of the ruling, we would have to see, what the application scope of the ruling would be. But that certainly could be one of the implications if it rules against the president. And so maybe, again, the Supreme Court just doesn't want to take that on. They don't want to rule in a way political and economic and sea waves across the globe.
Does Trump have other tools to impose tariffs?
The tool would be, I think the appropriate tool would be just simply to go to Congress. And so there's certainly nothing that prohibits the president from going to Congress and asking Congress to enact legislation that would authorize the president to impose tariffs on particular countries for particular reasons. You would think, in light of the fact that both the House and the Senate are controlled by the Republican Party, that he would receive a very receptive audience there, and they would respond accordingly and enact the legislation that the president has requested. But here, I think there's maybe something more fundamental, more basic that's at play here, and that's again the power of the executive branch. And we've seen a president that has been really pushing and stretching the limits of his Article 2 powers. So maybe that's even more important to the president, is being able to say, no, I have the authority. I don't have to go to Congress. I can do this on my own. I don't need Congress to support. But at the end of the day, as a pragmatic matter, he could accomplish what he's trying to accomplish by going to Congress. Of course, the process would be much slower in enacting the necessary legislation.
And procedurally, this is an appeal from a decision in May of the U.S. Court of International Trade, which struck down both the April 2nd Liberation Day tariffs and the migration-related tariffs. Was that a forceful decision from the U.S. Court of International Trade?
I think it was. The written opinion articulated many of the reasons and many of the arguments that were raised again before the appellate court, the federal appellate court, and which the federal appellate court seemed to agree that those arguments also seemed to resonate with the federal circuit. And so I think the underlying decision is sound based upon oral argument here before the Federal Circuit Court of Appeals. It appears that they're probably going to be incorporating many of those arguments and reasons that were articulated below in their opinion, if in fact they rule against the president.
You dealt with tariffs when you worked for the government. What struck you about these?
I found it significant. I did a little bit of due diligence on the opioid crisis and fentanyl, and the CDC in 2024 reported that there's been a 27% decrease in overdose deaths from fentanyl compared to 2023. And so even that argument, the unusual and extraordinary emergency is the fentanyl crisis, that has seemed to have subsided or reduced significantly over the last couple of years, last year, since 2024. And so I think it further undercuts the president's claim that, that's an emergency that justifies the imposition of tariffs against, Mexico, China, and Canada.
It will probably be several weeks before we hear a decision from the Federal Circuit Court of Appeals. Thanks so much, Jimmy. That's Professor Jimmy Gurule of Notre Dame Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.